Welcome to Is Arbitration Fair? Moderating the program today is Sarah Cole. Sarah, you may proceed with your program.
Thank you very much. I'm Sarah Cole, and I'm a professor of law at the Moritz College of Law at The Ohio State University. And I'm very pleased today to be joined in this program by Imre, Szalai, and Ware, two of the foremost scholars on arbitration in the United States. Imre is the Judge John D. Wessel Distinguished Professor of Social Justice at the Loyola University New Orleans College of Law. He is a graduate of the Yale University and received his law degree from Columbia Law School, where he was a Harlan Fiske Stone Scholar. Professor Szalai focuses his scholarship on arbitration law and has written a book setting forth a comprehensive legal history surrounding the enactment of the Federal Arbitration Act, entitled Outsourcing Justice: The Rise of Modern Arbitration Laws in America. His book reviews information and archival material from the drafters of the Federal Arbitration Act and explores why federal arbitration law today is radically changed from what it was in the 1920s. He has been quoted by national media in stories about arbitration and also maintains a blog about arbitration law developments. Professor Ware, a longtime friend of mine and fellow law school classmate, is also an esteemed professor at the University of Kansas focusing on arbitration law. He is the author of Principles of Alternative Dispute Resolution, as well as a co-author of Arbitration Law in America, A Critical Assessment. He has dozens of arbitration articles in both scholarly and popular journals, and has testified frequently before both houses of Congress and in court as an expert witness. He is a frequent speaker at academic conferences and CLE programs and has also appeared on television and on the radio and has been quoted in multiple national newspapers. So I hope we will have a terrific program today, and I'm certain after reviewing the slides that we will. And today we'll begin with Imre and then continue on with Stephen. Imre.
Thanks, Sarah, for the introduction, and thanks to the section on dispute resolution for inviting me to share about this topic. For me, the fairness of arbitration is a very thought-provoking topic, and I have a lot of criticisms as well as praises for arbitration, and I probably can't get through all of them with our limited time, but I'll cover a few to leave time for questions at the end. So to answer the million-dollar question, is arbitration fair? For me, that's a very loaded question, and to be frank, I have the most extreme Tom and Jerry love-hate relationship with arbitration. But in a nutshell, for certain situations, I think arbitration can be abusive and one of the greatest stains on our legal system. But in other situations, arbitration is better than sliced bread. It's a dignified, superior, efficient way to resolve disputes compared to litigation. And it's a shame that arbitration is abused because those abusive situations give arbitration a bad name. And I appreciate the New York Times and its coverage of arbitration in front page news over the last 2 years. But unfortunately, its coverage was one-sided. It did not accurately portray the many powerful fair uses of arbitration. Arbitration is a time-honored method to resolve disputes going back to before recorded history across many different societies, and I don't think we can or should get rid of arbitration. It's here to stay. So I strongly believe in and support arbitration. It is fully consistent with a democratic society that respects freedom and personal autonomy. And my plan for today, if we have time, is to cover 3 things in my presentation. First, I want to give a brief overview of some empirical evidence regarding arbitration. And next, I want to go over some good examples and abusive examples of arbitration. And finally, if we have time later, I want to conclude by looking forward. I want to share some ideas for reforms to make arbitration more fair. So first, I want to highlight a few empirical studies, and I just want to touch upon a few. On my handout, I have listed several other studies I won't be able to cover during my presentation. And first, I want to mention the outstanding work of Professor Ware's colleague at KU, Professor Christopher Hosel, whom I consider to be one of the leaders of empirical research on arbitration. I tremendously respect his work. I want to briefly mention a few of his findings from the 2009 Searley report on consumer arbitration for the AAA. It's a landmark study. First, the upfront cost of AAA arbitration for consumer claimants appears to be quite low. It's about $100 in fees for claims less than $10,000, and it's about $200 in fees for claims between $10,000 and $75,000. And this next finding is very powerful evidence for me personally. AAA consumer arbitration is a fast way to resolve disputes. The average time from filing to final award for the consumer was 6.9 months. And this amazes me. It's a beautiful, outstanding feature showing you the power of arbitration, where justice has the potential of being very swift. And also, consumers won relief in slightly over half, 53% of the cases they filed, and they recovered on average about $19,000. And this award was about half of the original amount the consumer on average was claiming or seeking initially. And finally, there was really no strong evidence of a repeat player effect. In other words, if a consumer sued a repeat player, a repeat user of the AAA, compared to a consumer suing a company using the AAA just once, the win rates for these consumers were about the same. And so the Szalai report is an excellent must-read study. Another well-known empiricist in the field of arbitration is Professor Alexander Colvin from Cornell, and he studies employment arbitration, where I believe more is at stake when compared to consumer arbitration. His study, published in 2011, contained many key findings, and here are a few. The employee win rate among the cases was 21.4%, which was lower than employee win rates reported in employment litigation trials, about 33% in federal court and about 50 to 60% in state court. And the average award in arbitration was substantially lower than awards reported in employment litigation. The median award amount in arbitration was about $36,000, and there are studies of employment litigation showing the median award in litigation was about $150,000. And the average time to resolve a case in arbitration was substantially shorter compared to employment litigation. It was only about 1 year for an arbitration award as opposed to 2 to 2.5 years for employment litigation. And this Colvin study did find some evidence of a repeat player effect. Employees fared worse when the same arbitrator was hearing multiple cases for the same employer. And the next study, I think, is the most comprehensive empirical study of consumer arbitration I've seen to date, although it's limited to the financial services industry. This is the March 2015 Consumer Financial Protection Bureau report on arbitration. It has so many findings, we could spend hours discussing the findings. I just want to highlight a few. And a very striking finding, again, for me, was the speed. Where an arbitrator issued a decision, or where the parties initiated the arbitration and settled, the decision or settlement took on average about 5 months. And another interesting finding from this study, the vast majority of consumers were unaware of the existence of an arbitration clause in their contracts. Almost 80% were unaware that their credit cards even had an arbitration clause. And if someone did have an arbitration clause in their contract, only about 7% of consumers recognized the significance of the arbitration clause, that it would block their ability to go to court. And these findings, they don't surprise me. I'm passionate about this field of arbitration, but when I try to describe it to other people, I'm often met with blank stares, like, what do you mean I have an arbitrary agreement or an arbitrary proceeding you're talking about? And to which I have to explain, no, it's not arbitrary, it's arbitration. And so it's very intuitive, and just based on my personal experience, that second finding here, it resonates a lot with me, that the vast majority of people are unaware of the significance or the meaning of their arbitration clause. And another interesting finding from this study is the following. When a court compels arbitration, when it issues an order enforcing an arbitration agreement, then you know what happens? Does the plaintiff rush to arbitration? No. In less than 25% of situations, the plaintiff consumers will actually continue pursuing their claim in arbitration. In other words, the order compelling arbitration actually terminates the entire dispute. I heavily recommend looking at this study. It's the most detailed, far-ranging empirical study I've seen in arbitration. There are a lot more interesting findings, like arbitration agreements. There's some evidence that it does not lower consumer prices, and there's so many other findings here. But based on this study, the CFPB proposed a rule in May 2016 that would ban the use of class action waivers and arbitration clauses in consumer financial products. And the CFPB was flooded with public comments regarding this controversial proposal, and the comment period closed in August of last year. What will happen next? Whether the CFPB will issue a finalized rule on class action waivers is difficult to predict. One issue is whether Trump has the power to remove and replace Director Cordray. The D.C. Circuit recently held that the president can remove the director at will, but this is the subject of a request for rehearing en banc before the D.C. Circuit. And if Trump does replace Cordray, and Trump has been rumored to be interviewing a replacement, I imagine Trump's replacement will completely shift the direction of the Bureau, and so the proposed rule will likely die out and probably never be issued. If Cordray does remain, even for a few more weeks, as the director, and if he's able to issue a final arbitration rule, Congress can probably block the rule from going into effect. The CFPB has to present the finalized rule to Congress under the Congressional Review Act, which provides for expedited procedures for Congress to review certain agency regulations. And under this statute, there's a possibility that the Republican-controlled Congress can block a final arbitration rule issued by the CFPB. Also, on Inauguration Day, the White House issued a memo, in effect putting a hold or freeze on agencies, asking agencies not to submit any regulations to the Office of the Federal Register until the administration reviews and approves of the regulation. And so in sum, there's uncertainty about the CFPB arbitration rulemaking, I think it's unlikely to go into effect, the final rule, and so we just have to keep an eye on this, but I think it's unlikely that the final rule will go into effect. And I want to share a few criticisms about these arbitration studies. I want to stress that there are valid critiques of these empirical studies of arbitration. None of these studies are perfect. For example, on my list of empirical studies, I included a report called Arbitration Summer Soldiers, and my colleague, Professor Ware, provided an excellent critique of this study, particularly that the types of contracts analyzed were not truly representative of all business or all consumer contracts. So the findings need to be taken with a grain of salt and viewed narrowly. And I completely agree with Professor Ware on this point. I share those exact same feelings and concerns for virtually every empirical study on arbitration. For example, the Szalai study. For the Szalai study, the primary data set was just 300 arbitrations. And some statistics from the CFPB study, which is the most comprehensive study, only involved a survey of just 1,000 people. And so looking at the bigger picture, where there are millions or tens of millions of disputes per year, the data sets in these empirical studies are just a grain of sand on the beach, a drop in the ocean, and I believe it's difficult to make firm conclusions concerning the rich world of dispute resolution. Imagine trying to derive accurate conclusions about the Amazon rainforest, but all you've been given is a speck of tree bark from one variety of tree in the forest. So I take these studies for what they're worth. They're interesting small snapshots frozen in time of this rich world of dispute resolution. They suggest issues to consider. But one criticism I have of these studies, they involve incredibly small data sets for such a large, complex universe. And another criticism I have of these studies is that not all arbitration is the same. This criticism has been recognized by Professor Drehosel in his Szalai study. He cautioned that he was studying just a small set of AAA arbitrations as opposed to all arbitrations. He said in a law review article that his AAA study is not necessarily representative of all consumer arbitration proceedings, and I appreciate Professor Drehosel's acknowledgement and caution. We can never forget how complex, how organic, how rich, how varied arbitration can be. And this is something that I love about arbitration. I've seen some arbitration proceedings governed by 10 simple rules. I've also seen arbitration proceedings that are so technical, they're more complex than any existing judicial system. Also, if you take a look at the variety and dozens of different rules administered just by the AAA over time, there's just a wide variety of arbitration. If you want to compare arbitration to some baseline, say litigation, I think we also have to recognize that court procedures across the country are just as or even more varied. So I think it's an error to speak in terms of arbitration as if it's a homogeneous process. In other words, there's a hidden pitfall in framing the question whether arbitration is fair. And the Supreme Court, I believe, makes this error all the time, which has been pointed out very persuasively by Professor Jill Gross in a law review article. She presents the case that I really believe this. The Supreme Court always seems to speak of arbitration as if it were some homogeneous, uniform proceeding. But arbitration, as we know, can be complex, rich, and varied. There's so many variants of arbitration. The Supreme Court, however, seems to display an overly simplistic, homogeneous, flawed, narrow view of arbitration. In AT&T versus Concepcion, arbitration was described as a simple, streamlined, one-on-one proceeding. And that concept of arbitration was central to the court's holding. And also, over time, you may have noticed that both the Supreme Court and lower courts tend to blur the lines with labor arbitration and commercial arbitration and employment arbitration. And there's a cross-pollination of legal terms from each field. My main point is that there's a flawed perception or treatment of arbitration as all being the same, homogeneous process, but it's really not. Arbitration proceedings are very varied. Because arbitration is a matter of agreement, the possibilities of different permutations and combinations of procedures are virtually limitless. So arbitration is so varied, it's difficult to make generalizations about arbitration as a whole. And even if we tried to eliminate the tremendous variety by focusing on our empirical research on just one single set of arbitration rules, I think there will still be variety even within a given set of rules. For example, if we picked one AAA set of rules, the accounting services rules from 2007, the 2007 version of these rules, let's say we collect 200 AAA arbitrations administered pursuant to these accounting rules. If someone gave me empirical win rates, like 45% of these 200 consumers won some type of relief against their accountant, I would reply, well, maybe consumer number 27 didn't get the opportunity for a cross-examination or for a deposition. And maybe consumer 157 got a chance to submit a post-hearing brief rebutting the opponent's arguments because both parties provided ad hoc consent to modify the rules. So even if we focus our empirical energies on one very specific type of proceeding, I am still skeptical of empirical data in arbitration. Arbitration has an informal nature to it, whereby the parties can alter the process at any time. and arbitrators have significant discretion and control over rules. In my classroom, I tend to have 40 or 45 students studying ADR, and I'll give them all the same exact arbitrations via a simple breach of contract case to teams or panels of 3 students apiece. And I'll have them hear a mock arbitration case, and I guarantee you from the 15 panels, I will receive 15 very different final awards. And under our framework of the FAA, which allows for very limited judicial review, all 15 radically different awards would be correct and fully enforceable. So for many reasons, I am skeptical of empirical data on arbitration. And I view such data as raising interesting questions and hypotheses, but I view such data in a limited way. We can't easily assume the empirical research is representative of all arbitrations. So on my handout, I've listed several studies. And if we did a meta study and combine all the results of the existing studies, my biggest takeaway from these studies would be the following. I'm hesitant to draw conclusions from these studies, but the one statistic I place the most confidence in, the most faith in, is the following. There is repeated proof across studies that arbitration is swift and swifter than litigation. If you give me a commercial dispute and give me 2 other panelists, 2 other arbitrators with a streamlined, well-established set of rules, I would bet that the 3 of us can run circles around any state court or federal court judge in our ability to issue a decision in a matter of a few months. So arbitration has the great potential to provide for the timely resolution of disputes, especially in an environment with overburdened courts and shrinking court budgets. I was recently helping some family members with a dispute in Miami-Dade court, and several people warned me that the backlog in Miami-Dade is very noticeable, and if venue would lie in some other county in Florida, in Fort Lauderdale, Broward County, would be better off. But the only venue for this case, unfortunately, was Miami-Dade. And I called the clerk's office to inquire about a technical procedure, and the recorded message I received was due to budget cuts. The clerk's office in this particular division could only answer questions at limited times on one day, and the system hung up the phone. And for me, just from this basic concept that justice delayed is justice denied, the swiftness of arbitration, which has been demonstrated in several studies, presents a very powerful argument that arbitration is indeed fair and in fact better than litigation. And if you add to the mix the ability to mutually select an expert decision maker who can focus on your case instead of being distracted with hundreds of other cases on a larger docket, then for me it's a slam dunk. You really have a powerful, fair method of dispute resolution, superior over litigation in my mind. And I'm a big fan of the history of arbitration. And when I look back at its history, especially in the commercial context in America, I believe the history suggests an answer to the million-dollar question. Arbitration was the norm for many business-to-business disputes, and going to court was the alternative method of dispute resolution. And so just to wrap up this empirical data, let's assume that one day we have an all-knowing arbitration God with unprecedented access to every arbitration proceeding across all fields, who conclusively determines once and for all that arbitration is a cheaper and more efficient, superior method that produces fair results as compared to courts. I don't know what that would change in terms of my personal vision for arbitration policy. I would say great, whether arbitration is efficient or inefficient, whether it costs a little or a lot, whether there's a repeat player phenomenon or not, whether awards are higher or lower than litigation. I would say the following. For the people who choose to arbitrate, let them arbitrate. And for the people who choose to litigate, well, let them litigate. In other words, let people choose for themselves how they want to resolve disputes, and our legal system should promote meaningful choices. And the Russians have been in the news a lot the past few weeks, and I've been reminded about the values of democracy. My father's Hungarian, and as a kid, when I was a child, I traveled to Hungary when it was under Soviet control during the Cold War in the 1980s, when literally every family drove a tiny little boxcar called a Trabant. And this car was manufactured in East Germany. The interior dashboard was literally made out of thick cardboard, and the engine was as powerful and loud as my lawnmower. And my cousins were amazed that we had a Ford in America. And I was like, you've got to be kidding me. And personally, I want to live in a society where I'm not forced to accept a Trabant as the only car I can drive. And in the same way, I don't want to be told what type of dispute resolution method I am forced to take. And so my view of dispute resolution policies, let's assume that arbitration has benefits. And I don't think we have to assume that. I accept that and personally believe that, especially for speed and the ability to select an expert decision maker. My view of dispute resolution policy, it's really a free market argument. Let's give people a meaningful option how they want to resolve disputes. So like a kid in a candy store with so many options, let's try to give people meaningful choices as to how they want to resolve disputes. Arbitration law should respect party autonomy, which is fully consistent with our democratic values, and let's maximize people's choices. If they want method X, Y, or Z to resolve disputes, great. So is arbitration fair? From the perspective of the existing empirical evidence, there are many problems with the empirical evidence, but I believe the data, as well as my intuition and experience, they confirm the potential speed of arbitration. And together with the ability to select an expert decision maker, I would say arbitration can be better than litigation. And instead of focusing on empirical data, I would say let's identify problem areas with arbitration and work on fixing those problems, continuously striving to improve arbitration. So next I want to point out some abuses of arbitration as well as some stellar uses of arbitration. And for these abuses, it's unfortunate. These abuses give arbitration a bad name. And my first critique is that stronger parties can sometimes use arbitration as a means of claim suppression. I've seen examples of harsh arbitration clauses where a consumer or employee is asked to bear significant costs up front, or the statute of limitations is shortened to 3 months instead of several years, where their proceeding will take place in a distant location, where all discovery is banned, so there's no opportunity to depose a key witness or demand documents in advance, where the arbitrators are first selected and proposed by the corporation, and where the consumer has to select from the provided list, and the arbitrator's ability to issue remedies is limited. And I suppose a company can try to justify such a harsh clause with a thinly veiled argument of efficiency, but what's really going on is that the stronger party is designing the playing field so that it tilts heavily in its favor. And there are many examples of this. Take a look at this language from the Bragg case. The court here said that taken together, all of these harsh, different arbitration provisions, they demonstrate that the arbitration clause is not designed to provide consumers an effective means of resolving disputes with Linden, the corporate defendant here. Rather, it's a one-sided means which tilts unfairly in almost all situations in Linden's favor. Look at cases involving the payday loans from Western Sky Financial, where the lender charged illegally high interest rates and consumers were bound to arbitrate before the Cheyenne River Sioux tribal nation. And the Seventh Circuit here found that the entire arbitration clause was a sham from stem to stern. The tribal nation had no rules and had never administered a consumer arbitration. And in the Western Sky Financial case with the sham arbitration clause, I really believe the arbitration clause was intended to scare away consumers from bringing any claims instead of a good faith effort to resolve disputes. Or there's the infamous, often cited Hooters case from the Fourth Circuit, where the arbitration clause was heavily tilted in favor of the employer. I want to stress that I'm not saying all arbitration is like this, but I do see some evidence of arbitrations being used to suppress claims instead of designed to resolve disputes in good faith. So one way I think arbitration can be unfair is where arbitration is used as a way of claim suppression. And again, this is not an attack against all arbitration, but I've seen examples of this abuse of harshly drafted terms, particularly in the employment and consumer context. And a second way that I think arbitration is not fairly used today is that the law applied by the Supreme Court is not the law enacted by Congress. The court constitutionally cannot alter or rewrite Congress's laws. And Justice O'Connor years ago, frustrated with her colleagues, once wrote that the FAA is now an edifice of the Supreme Court's own creation. The system that we see in place should not exist. The FAA was never designed or fine-tuned to support the broad, expansive uses of arbitration that we see today. And so for better or worse, years ago, Congress back in the 1920s already made the policy choice that the FAA does not cover employment disputes. But in more recent years, in 2001, the Supreme Court in Circuit City erroneously held the FAA applies to all contracts, including employment contracts. Also, there's an explicit contract limitation found in the statute, which I believe the Supreme Court has unconstitutionally altered. The FAA only covers arbitration clauses that govern disputes arising from those contracts. And I can explore this later if we have time for questions, but I don't believe the FAA was designed for tort claims or statutory claims, which I think by definition do not arise out of a contract. And again, Congress has already made this policy choice, but the Supreme Court has unconstitutionally rewritten the law because of the docket clearing efficiency of arbitration. And the FAA was designed to apply solely in federal court, and the court's expansion of the FAA to state courts is one of the court's greatest mistakes in the area of federalism. I really believe it should be up to each state to decide how it wants to handle arbitration contracts, but the FAA applies in state court and overrides state sovereignty. If you take a look at the Preston case from 2008, this involves a California law regulating talent agents in the Hollywood entertainment industry, and the state of California created its own specialized administrative tribunal to handle these disputes. But under Preston, the FAA completely displaces this carefully designed administrative system to implement unique state laws. The FAA interferes with the ability of a state to implement and design and enforce its own state-created policies. Now, these are just a few criticisms of how the FAA works today. I don't think it's a fine-tuned system with a broad, expansive use of arbitration that we see today. I just want to switch gears and turn to some benefits of arbitration. And I've mentioned and stressed one already. Obviously, one is speed. And also, arbitration, a second benefit, arbitration is an invaluable part of our legal system. It serves like a safety valve for an overheated court system. And for me, when I was in practice, I was accustomed to looking at the FAA solely in terms of how the FAA would shape a dispute between my client and the opposing party. But arbitration goes far beyond the narrow plane of resolving disputes between two people. I really think that arbitration supports justice by preventing a meltdown of the more traditional court system. In other words, on a broader plane, society should have a very deep interest in promoting arbitration. And also, there's another interesting dynamic between arbitration and litigation. When I study the reformers who passed the FAA during the 1920s and how they were frustrated with broken court rules of the time, this reminds me of a very powerful aspect of the FAA. The FAA grants people the power to create procedures to resolve their own disputes. And this view of the FAA highlights the spirit of innovation and creativity. And with this power, there's an opportunity to improve dispute resolution. So there can be procedural experimentation through arbitration, which could lead to improvements in courts themselves. I sometimes think of arbitration clauses as small procedural petri dishes or laboratories where the parties can immediately develop and implement new innovative systems for dispute resolution. And about 2 years ago, the New York state courts created more streamlined procedures for their court cases. And do you know where they got the ideas from to reform their court rules? They got it from commercial arbitration. And so taking a broader perspective, one very positive aspect I love about arbitration is the room for procedural experimentation and innovation. And this can stimulate broader changes in the legal system and how we resolve disputes. And one final example of a tremendous benefit of arbitration, I think I'm out of time, is the Bangladesh Accord and the power of arbitration for self-regulation. Large companies have been accused of engaging in human rights violations, and unfortunately it can be difficult to get justice in a courtroom setting for human rights violations. About 4 or 5 years ago, a garment factory collapsed and killed more than 1,000 people in Bangladesh. And about 200 apparel companies facing public pressure, they developed and signed the Bangladesh Accord. And these are major brands like Abercrombie & Fitch, Adidas, Hugo Boss, and H&M. And the Accord sets forth substantive safety standards, but what I find fascinating are the terms providing for binding arbitration of disputes arising from the Accord. And so arbitration is being used here in a powerful way to provide justice where there are gaps in the traditional legal system, where traditional law and traditional courts have failed. And so arbitration can be an integral part of their system of self-regulation. And so the Bangladesh Accord reminds me of the good in arbitration, how it can be superior to a traditional legal system. So I'm out of time, and I have some ideas for reforms maybe I can share later on. Thanks.
Thank you so much, Imre. And now we'll turn to Steve for his perspective.
Thank you very much, Sarah, and thank you, Imre. Just want to thank them both again for the audience benefit. Imre really has been a wonderfully enthusiastic contributor to arbitration scholarship for many years now, and Sarah, deeply accomplished scholar, not just of arbitration, but more broadly alternative dispute resolution, and really appreciate their good work in putting on this program. And see if I can advance the slide now to my first slide after Imre's remaining slides that he didn't have time to. Here we go. So hopefully my slide is on the screen now. Is arbitration fair? That's the program title. And my next slide shows an interest group that emphatically says no, arbitration is not fair. This is from the American Association for Justice, which is the plaintiffs' trial lawyers organization, describing arbitration as a license to steal forced on America by the U.S. Chamber of Commerce. And I don't think the plaintiffs' lawyers here are criticizing all arbitration. I think they're focused on consumer and employment arbitration arising out of adhesion contracts. Plaintiffs' lawyers organizations have taken to calling this arbitration forced arbitration or mandatory arbitration. In contrast, I think arbitration arising out of adhesion contracts is better called adhesive arbitration because it emphasizes really the two sides of adhesion contracts, that they are adhesive, but nevertheless they are contracts, so not fully forced or mandatory. But this slide shows a very negative view about the fairness of arbitration from an important interest group, plaintiffs' lawyers. And this interest group has been in a battle over arbitration for about 30 years now, basically a battle between businesses and the lawyers who sue those businesses. This interest group battle has translated for many years now also into a partisan battle between Democrats and Republicans, which I'll show on the next slide. Here is bumper stickers from the Democratic Party describing also arbitration as a license to steal. And this is from the Cumberland School of Law in Alabama, where I was on the faculty until 2003. So these bumper stickers date from the late 1990s. And it's not just Alabama in that era where arbitration of consumer and employment disputes has become a partisan issue. The partisan divide on arbitration, adhesive arbitration, is evident throughout all three branches of the federal government, the Supreme Court, the Congress, and executive agencies. Basically, in the Supreme Court for many years now, we've had slim majorities of justices appointed by Republican presidents issuing decisions that enforce adhesive arbitration agreements, and there's dissents from the justices appointed by Democratic presidents. That partisan divide in the Supreme Court is matched in Congress, where Democrats have introduced bills to overturn some of those Supreme Court decisions by justices on the Supreme Court appointed by Republican presidents. Some of these bills have passed, the most notable probably being the Dodd-Frank Act, which prohibited arbitration clauses in mortgage loans. However, Republicans tend to oppose these bills, so I wouldn't expect any more to pass in the next 2 years, which moves the action to administrative agencies, in particular the Consumer Financial Protection Bureau, which, as Imre explained, has proposed a rule to prohibit arbitration agreements provisions prohibiting class actions. We call them class action waivers. And the CFPB did this while headed by a Democrat, Richard Cordray, who, as Imre says, may or may not be allowed to remain head of the CFPB. So we'll have to see what the D.C. Circuit's full en-banc decision is and what President Trump does. If you want to learn more about the partisan battle over arbitration, you can read my law review article now cited on the slide. I'll give just one quick summary, though, of what I think is the basic dividing line, because I think this division very much shapes the issues of this program, this webinar now, which is the partisan divide over adhesive arbitration is basically about the level of consent the law should require before enforcing an arbitration agreement against an individual, such as a consumer or employee. Progressives, Democrats, would generally require higher levels of consent than arbitration law currently requires, while conservatives generally defend current arbitration laws' relatively low standards of consent. That, I think, is the big political and ideological divide that shapes the issues discussed in this webinar. And here we have a list of the questions that Imre and I were asked to address for this webinar. So I'll now walk through them one by one. First one, the meaning of fairness in dispute resolution. I think it's useful to distinguish the process of reaching an outcome and the outcome itself. In other words, number two, how is the dispute resolved? What are the terms of the decision for from an arbitrator or other outcome of a dispute resolution process versus the process itself? Did it give an opportunity for each side to be heard? Was it a fair process? Was it an efficient process, etc.? So as I point out on the screen, both of these factors, 1 and 2, can be assessed in terms of quality and cost. There may be a trade-off. Higher quality processes may cost more. And doing these assessments may not be the same for each party. One party may see more quality in an arbitration process than the other party sees similarly costs. When comparing arbitration and litigation may shake out differently for one party versus the other. And then I think the real big question is at the bottom of this screen, which is these assessments, which are inevitably uncertain. As Imre said, it's not as though we're going to ever have empirical data that answers in a final, conclusive way these kind of assessments about cost and quality on arbitration. Given that uncertainty of these assessments, to what extent should these assessments be made by lawmakers, those three branches of government I had on the previous slide, legislature, courts, and agencies, or should these assessments be made by the parties? And if so, should the assessments be made or in pre-dispute agreements or post-dispute agreements, which goes to that ideological divide I described about the level of consent that should be required in the law before before courts enforce an arbitration agreement. So now moving on to the second question in our webinar here, when does arbitration provide more or less fairness than litigation? I start with that question, fairness for whom, again acknowledging that the adhering party, the consumer, employee, or other individual, and the business may have different perspectives on fairness. And are we interested only in fairness to the party that is presented with the adhesive arbitration agreement, or do we also factor in fairness for the business that drafts the adhesive arbitration agreement? And in digging deeper on that, I think it's very important to distinguish individual actions and class actions. In other words, in comparing the fairness of arbitration with litigation, I think we need to ask ourselves separately to compare the fairness of individual actions in the two forums and compare class actions in the two forums. And I emphasize that class actions may be the more important of the two type of actions. So here I quote the CFPB emphasizing how rare consumers' individual claims are. In other words, it may be not an arbitration versus litigation issue. It may not matter what sort of forum we're talking about. Individual consumer claims may be rare in any plausible forum, and different reasons might explain that. So if that's right, that individual claims sort of less at stake than class actions on this debate about the fairness of arbitration, we really do have an uphill battle, I think, in that class actions have been a huge contested aspect of our legal system ever since the 1970s, when they spread in frequency. Back then, Harvard law professor Arthur Miller described a holy war over class actions, with one side seeing the class action as a knight in shining armor, while the other side saw it as a Frankenstein monster. And that is not much of an exaggeration about how those two interest groups I mentioned before view class actions. And that holy war from the 1970s has really continued unabated till today, and shows no signs of ending. And that holy war over class actions transcends, it's much bigger than the battle over arbitral class waivers, arbitration agreements enforcing provisions prohibiting class-wide relief, are really just a drop in the bucket of this bigger war over class actions. I quote here on the slide Professor Deborah Hensler and her co-authors explaining that this class action debate is unlikely to go away anytime soon or be resolved anytime soon, because it's a deeply political question implicating fundamental beliefs about the structure of the political system, the nature of society, and the roles of courts and law in society. This political question is unlikely to be resolved soon. Class actions are that important, really fundamental divide in how we view the role of legal system in society. So what does all that mean for arbitration law? Narrowing back down to the specifics of arbitration law, I think the prudent thing for arbitration law to do is to get out of this holy war, to not take sides in it, to get out of the crossfire by leaving the battlefield. And I suggest in my article a way to do that, which is point 1 on the screen now, which is arbitral class waivers should be as enforceable, neither more nor less enforceable, than non-arbitral, that should say arbitral class waivers. In other words, some non-arbitration agreements have provisions requiring individual rather than class resolution of claims. And courts have been faced with whether to enforce those or when to enforce them and when not to enforce them. I think that law ought to be mimicked by arbitration law. In other words, arbitration class waiver clause ought to be treated the same way as non-arbitration class waiver clause, just as a way of saying, look, class actions, that's a big separate issue from arbitration. Let's not have arbitration law take sides. I think the Concepcion decision and the Amex decision from the Supreme Court are taking the anti-class action side in the war, taking the business interest group side in the war, and what a lot of Democrats and plaintiffs' trial lawyers have proposed, Arbitration Fairness Act and so forth, that would take the other side of the holy war, that would take the pro-class action side of just allowing class actions to proceed no matter what the contract says. And that really is what the CFPB has proposed with respect to class actions, is taking the plaintiff's lawyer's side of allowing them to proceed and not enforcing arbitral class waivers, in contrast to the Supreme Court's decisions in Concepcion and Amex. And again, I propose an intermediate position. I propose what I think of as a centrist position, which is just enforce arbitral class waivers to the same extent courts enforce non-arbitral class waivers, and that's very consistent with the overall federal arbitration law. Section 2 of the FAA basically says enforce arbitration agreements, save upon such grounds as exist at law or in equity for the revocation of other contracts, meaning arbitration agreement law should mimic or copy other contract law. I think that point ought to continue and be applied to class waivers in particular. So I do concede point 2 up on the screen that although I don't like the outcome of the Supreme Court's Concepcion and Amex decisions on class waivers, I do think it's a defensible interpretation of the statute, and that, of course, is the Supreme Court's job in interpreting statutes, is not to make the right policy, but to interpret the statute as it's written. And Congress, of course, as I say in point 3, can change the statute, which is the debate in Congress over the Arbitration Fairness Act, or it can now be changed, at least with respect to consumer financial services, by the agency, by the CFPB, where you see there in point 4, I suggest that that rule goes too far in the other direction, the proposed rule from the CFPB. So that's my view on the class action topic. And moving now back to the individual claims, the non-class claims, here I think we have this empirical question that Imre raised. do comparisons of comparable cases show a difference in outcomes between arbitration and litigation? And I think the tentative answer is probably not, but it's got to be a tentative answer because no empirical study can eliminate the possibility that differences between the two sets of studied cases explain any difference in outcomes. And that hesitance or skepticism about empirical data comparing arbitration and litigation is endorsed by the CFPB. Its report, I quote up on the screen here, goes into great detail about all the possible ways arbitration and litigation could differ that would make outcomes differ. That said, if we want to try to compare apples to apples, similar cases in arbitration and litigation, I think the best study for it is a different Drohozel study than the one Imre mentioned. This one is about creditor claims against consumers. That was, I think, the best attempt to compare similar claims in litigation and arbitration. And you can see the outcome of the study here, which is basically consumers doing pretty well in arbitration. So that's, I think, the best empirical data we have on individual claims, although it's claims against consumers as opposed to claims by consumers. And then since I only have a couple of minutes left, I will just quickly point out the points about costs can be similarly analyzed separately as look at the cost to the adhering parties, the individuals, versus the costs for the businesses that draft arbitration clauses. And then we're asked to discuss the role of arbitration institutions like the American Arbitration Association and so forth. And here I just want to emphasize the point that we have real humans with real institutions. We're all flawed. Nothing will be perfect. So let's not imagine that litigation is some hypothetical wonderful thing and arbitration has flaws or vice versa. Let's compare the real processes, warts and all, and recognize the point Imre made, which is that arbitration takes some stress off the public sector courts. And arbitration, unlike litigation I show on the screen, does not receive a subsidy from the taxpayer. So arbitration will inevitably have a cost disadvantage when compared to litigation in terms of paying for the arbitrator. I think the big picture on this minimizing costs and promoting fairness is the one Imre really nicely displayed with the Soviet-era car, which is arbitration has competition in markets, competition among arbitration institutions and among arbitrators, whereas courts, the competition to promote fairness happens within the public sector. So finally, the question of what type of changes should the arbitration system have. I cite again my article, which anybody can go look at in detail. But I do have a quick table summarizing what I think are the best reforms, and I have it categorized left and right, progressive versus conservative, where I put in bold there what I think ought to be the outcome. This is what I call my centrist approach, which is, yes, we should enforce consumers' adhesive arbitration agreements according to usual contract law standards, but I have on the left in bold the three changes to current law that I've advocated in print that I think would soften the problems with arbitration, not solve completely, but the abuses that Imre refers to, I think, would be best handled with these three reforms I list. Do I think that's what's going to happen? I'm not sure. What I do think is going to happen is continued partisan voting on the Supreme Court and Congress. It really is a very political issue, and we mentioned, both of us, what will the full D.C. Circuit do on the CFPB's initiative. So with that, I'll end my presentation and cede the screen to Sarah.
Thank you so much, Steve. And we have a few minutes where we've decided to let Steve and Imre sort of discuss topics that they heard or issues of interest they heard from each other's presentations, and then we'll turn to questions from the audience. So Steve or Imre, do you have some comments you'd like to?
Yes, I would love to. Steve, your table, this is I'm going to put up the slide again. this table, setting forth the two columns, the progressive and conservative views, I think this is the best summary, cutting straight to the chase, what I affectionately call the arbitration wars going on for the last several decades. And I was wondering, can I borrow this from my class? It's incredible.
Yes.
But if there's no better summary, and I have a question about the conservative view, it's accepting implied consent. What would you say? I just want to show you these. Let me put up the slide. I want to show you these two situations. On the left, you see a screenshot of a smartphone signing up for an Uber ride. And on the right, I don't know if you can make it out, it's a Barnes & Noble's website for purchasing books or other items. And in my view, I would not enforce the arbitration clauses in connection with either of these two transactions. But how would you justify implied consent in these situations?
Well, Imre, your question is so good in part because it's so pervasive. In other words, your question about manifestation of assent, to use the contract law language, to form contracts, adhesion contracts, that transcends arbitration clauses. Courts have been dealing for generations with the challenges of adhesion contracts. And so I continue to believe that a prudent approach for arbitration law is don't reinvent the wheel. In other words, courts in contract cases for generations have been adjusting doctrines like unconscionability, like reasonable expectations to deal with those problems, and I think applying the wheel that's already been invented to arbitration clauses, just as courts apply it to other clauses, is the position arbitration law ought to take.
Now, I agree with you that we have a well-existing body of case law, contract law for decades that we could use here. And I do see the overall benefits to arbitration with lower process costs, but there are abusers of arbitration clauses who draft overly harsh clauses. And 10 years ago, I would have said, leave this up to the judges on a case-by-case basis. Do not reinvent the wheel. You can police, monitor, and validate harsh clauses using contract defenses. But I really think that the legal framework has shifted since Concepcion and American Express. Now, I would argue that today it is more difficult for judges to monitor and police arbitration clauses for fairness, especially with the Rent-A-Center case. And I think the old unconscionability arguments, they're now being viewed as preempted under Concepcion. I want to show you this quote from this is a case from the Northern District of California. And this case involved a harsh arbitration clause with a one deposition limit, like a very severe discovery limit. And the court recognized that, before Concepcion, it could have found this clause to be unconscionable. But now, because this argument that there's an unfair, severe, harsh arbitration term, it's arbitration specific, it's now preempted by Concepcion. And so I don't think that the current framework is doing a good job in policing the fairness of harsh arbitration clauses. 10 years ago, maybe, but not so much today.
Go ahead, Steve.
Imre, to reply, may I take control of the screen just for a second?
Oh, sure.
I think Imre's point is exactly right, which is that courts' ability to use unconscionability and other doctrines has been weakened by recent Supreme Court decisions like the Concepcion and Amex decisions that Imre mentions. And that's why I have on the screen now in bold on the left side the reforms I think are called for, whether it be by Supreme Court changing some of their decisions, or Congress enacting a statute, or CFPB enacting a rule. I think it would bring you back, Imre, to the 10 years ago situation where you liked courts policing arbitration agreements. So I'm with you on that.
Okay.
Go ahead, Imre.
With the old contract law, like coming from an old brick-and-mortar world, when you'd say, like, you're physically handed a written contract, many courts would say you had the duty to read all of its terms. Would you still accept that as a legitimate rule for applying to arbitration clauses today?
Well, same point I made earlier, which is that's a broader question brought to us by the Internet and other technology that transcends arbitration clauses. In other words, arbitration clauses are not the only electronic form contract clause that raises those issues. And again, I say it's not arbitration's job to reinvent contract law for the Internet age. Courts are doing that already, and let's just have that wheel applied arbitration.
You know, I would argue, like in the past, every single term in a physical written contract is reasonably accessible. Every term should be treated as conspicuous. But today, with online transactions, not all terms is as readily or reasonably accessible. And I agree, this debate is bigger than arbitration clauses. It's a bigger debate in contract law. But with online transactions, it's almost like the drafter has cut up the contract with a pair of scissors and distributed the pieces of that contract in different locations in the virtual world so that not all terms are readily accessible. And just for me personally, I wouldn't want to treat an arbitration clause in the exact same way as a pricing term or the terms for a warranty. I think so much more is at stake, especially in the employment context. I'm comfortable with singling out arbitration clauses for different treatment. And there's a wonderful case for the Second Circuit. Sotomayor wrote it when she was in the Second Circuit. It's called Speck v. Netscape, where the court recognized there the arbitration terms for an online agreement must be conspicuous. And I think that decision itself, it's subject to preemption under Concepcion. This doctrine is heavily used in the arbitration context, and so I think it's vulnerable under Concepcion. So I think there has to be, in my personal opinion, there should be reforms of arbitration law, and I just don't like the current system right now. I think it's too much of a system of just rubber stamping arbitration agreements.
Hey, let me interject and thank both of you so much. And this part of the panel presentation is now concluded, and we're ready to take questions from our live audience. All attendees can submit questions via the chat feature on the webinar interface. While the questions are coming in, our operator will provide the code to receive CLE credit. Operator?
Thank you. We will now give you your ABA participation verification code required to receive CLE credit for this program. You will be asked to enter the code in the online attendance form following this program. The ABA participation verification code is 767-39499. That code again is 767-39499. I'll now turn it back over to Sarah for audience questions.
Thank you, Operator. We'll now begin the question and answer portion of the program, and we have a question from our audience. Given the success of metadata analysis, the position that cost and quality cannot be measured seems ill-founded. The questioner asks whether you agree or disagree. Imre, I want to start with you.
Sure. I don't think we can ever have a conclusive answer. But we can get limited snapshots, and so I think it's worthwhile to continue studying, but understanding that all these studies would just be limited snapshots suggesting a hypothesis. And something that I'd like to follow up on with studies, I agree, there should be further studies. But just to take them with a grain of salt, I think there should be further studies to see, does arbitration truly lower consumer prices, which is a very popular justification for arbitration. And the CFPB study found no such evidence. But I would like to expand that study in other fields, like employment arbitration or more broadly consumer arbitration. But so I think there still is value. You will not get conclusive answers, but just limited snapshots.
Steve, do you have any thoughts on this?
Yeah, ultimately it's a very deep question that I think goes to epistemology. What is knowledge? What counts as knowledge? In empirical data, the rigorous method of natural science is to have a controlled experiment where only one variable impacts results and everything else is controlled. And we just cannot do that in human behavior, including arbitration versus litigation, the choice of forum. There will always be several variables distinguishing the cases going to arbitration from the cases going to litigation. We'll never be able to control for them all perfectly to develop truly apples-to-apples comparisons. So I think we'll always need to have a healthy skepticism toward any empirical study where we ask the author to go into great detail documenting the comparability, the similarity of the cases in arbitration and the cases in litigation, and even doing that won't succeed in solving the epistemological uncertainty for the reasons the Consumer Financial Protection Bureau pointed out, which is the cases that don't make it to the sample because they were never brought, because of decisions to settle, etc. We'll never be able to study those because they're simply outside the range of an empirical researcher's reach.
Thank you, Steve. I'll ask my own question here, which is interesting to me. If you go back to your chart, Steve, that Imre and I both admire, one of the things that I think has been interesting in the Academy is that most arbitration scholars, if not all, have agreed that the class action waiver problem is probably the most significant issue with arbitration today, at least with respect to consumer and employee arbitration. Given what's probably going to happen with the CFPB, should we give up hope about legislation designed to avoid these class action waivers? And if so, what else can we do? And Steve, why don't I start with you this time?
Well, I never give up hope, and the beauty of taking the centrist position I take, which is between the Supreme Court's views in Concepcion and Amex on the one hand, and the CFPB and Democrats in Congress view on the other hand, I can always hope for a compromise between the two views, which settles on my proposal of, hey, courts, just enforce arbitral class waivers in the same way you enforce or not enforce non-arbitral class waivers. So I always hope that there's reason on both sides that says, yeah, that's a good enough compromise. What Ware is proposing, let's do that.
Imre?
Yes, this there's an ongoing arbitration war, but the class action issue is the holy war, Steve pointed out. And what was very telling to me, I love Alec Kaplitsky. He's an excellent attorney. But if you saw his response to the CFPB proposed rule, it was very telling for me. I think he said publicly several times that if the CFPB banned class action waivers, his clients would no longer use any arbitration clauses, which suggests to me that the primary reason they desire arbitration is to eliminate class action liability. And what can we do for this issue? How can we solve it? I don't think Congress will. But the pending Murphy Oil, the Murphy Oil cases, there's a series of 3 cases. The Supreme Court recently granted cert in these 3 cases. It will be heard, I think, later on in April. I think the court, at least for the employment context, may come up with a solution. And these are the NLRA cases. I think that's worth to follow. But if you disagree with class action liability, if you think it's a problem, I have 2 responses. I would take a look at Wells Fargo and just assume they engage in widespread harm and fraud in churning bank accounts where they charge thousands of customers like $10 each in unauthorized fees. Without a class action remedy, I really see that an arbitration clause would give them complete immunity. And I don't think there is a concern about class actions. It's much broader than arbitration. I would say don't hide behind an arbitration clause to solve the class action problem. Let's directly fix class action procedures, limiting perhaps. I used to defend class actions. I saw my fair share of abuse on all sides. And I would say let's tackle the problem directly, perhaps limit the availability of class actions, but let's not fix it through an arbitration clause. I think that for me the Wells Fargo example is very striking. I think that shows us why we have to have class mechanisms.
Well, what about class action arbitration? There have been articles suggesting that companies are loath to try class action arbitration, but to the extent it was used post-Basel to sort of address some of these problems, it actually seemed to work pretty well, at least at encouraging the parties to settle. Imre, what do you think about that as a solution? Are companies not giving it a chance?
Yeah, because of the potential for collusion, which already happens in court, I am hesitant to send a class action into arbitration with limited reviews. I have a question, just how do we even verify consent in a class action context? Like with traditional judicial class actions, the law will deem you to be a member of the class. But if you're talking about class action arbitration, fundamentally, how do we verify, that consumer number 567 has consented to this tribunal? I have multiple concerns. For many reasons, I strongly dislike class action arbitrations.
Steve?
I think I agree with Imre on this, which is the procedural due process concerns, the constitutional concerns about notice and consent from absent class members. Those are serious points that really are a challenge to class-wide arbitration. And the point Imre and I both made earlier about arbitration as a sort of market-oriented, flexible process, if parties aren't choosing class-wide arbitration, I think that tells us something important. And as long as the Supreme Court decisions in Concepcion and Amex remain good law, it's hard to see why a lot of businesses would go for class-wide arbitration. I hope the CFPB and Congress don't try to force class-wide arbitration on a market that doesn't want it. I agree with Imre's point, which is the way I tried to phrase it earlier, which is a solution to the class action wars is just beyond the scope of arbitration law's mission.
Steve, I'm glad you mentioned due process. You know, with class actions in court, they raise the most heightened due process concerns. But think about arbitration. By definition, in many cases we'll say arbitration is completely private. There are no due process rights. And so I have a concern with how do you define class procedures virtually from silence in a contract? Like, if an arbitrator decides to hold a class action, which rules do silence automatically give rise to? So I have a problem with just these types of mechanisms raise the most heightened due process concerns, but there really are no due process rights in a private class action setting, in a private arbitration. And also, with class action arbitration, I've seen a race. Really, it's a race to the bottom, where both a friendly plaintiff's attorney will get together with the defense counsel, and they'll race to a judge who will rubber stamp the arbitration. That will rubber stamp the class action settlement. I think those risks are heightened if it's out of court, if these class actions are entirely settled through a private arbitrator. I think the race to the bottom will be even more severe with a class action arbitration process.
Thank you so much. I want to return to our first questioner who wondered if you would speculate a little bit about the impact of a metadata analysis of the various empirical studies to determine whether that might provide greater information about the viability or efficiency of arbitration. Steve?
Well, this is Steve just saying that garbage in, garbage out. In other words, if you don't have good data going into the study, you can't be rock solid confident in the outcome. And just using the word metadata doesn't enable a researcher to overcome the challenges of getting data on comparability of cases, and then what happens to all those potential disputes, potential claims that never made it into either forum, litigation or arbitration, in the first place. So I do not believe advances in metadata make any significant gain in reducing the epistemological challenges of comparing comparable cases in arbitration and litigation.
Imre?
Yes, regarding metadata, I do think if there's a meta-study analysis of all the, bringing together comprehensively all the different studies, I believe it will show that there's inherent speed, a possibility for speed with arbitration. I think that will demonstrate the fairness, the superior fairness of arbitration litigation. But in the end, even if we can prove with absolute certainty or near certainty, fairness issues, looking at statistics, I would say, so what? In terms of my vision for policy, I would say even if arbitration is cheaper, more efficient, and faster, my big takeaway is just that people should have a meaningful choice. Do they want to arbitrate or do they want to litigate? Regardless of the cost, regardless of the speed, it should be ultimately up to each individual's choices that I think the law should maximize.
Thank you so much. And let me go back to a question that we talked about earlier, which is, what do we do about the Federal Arbitration Act? Imre, I think you have some suggestions for potentially amending it to address some of the issues we've discussed today.
Yes, arbitration agreements have exploded in American society over the last few decades. And what should we do with this system? One suggestion I have is for the court or Congress to overrule Southland, which is held that the FAA binds states. It overrides conflicting state laws. And Bo Rutledge wrote an excellent book called Arbitration in the Constitution, and he recognizes if we get rid of Southland, we would definitely sacrifice the uniformity provided by Southland in the enforcement of arbitration agreements, but at the same time, overruling Southland will help promote federalism values and spur innovation among the states to regulate arbitration different creative ways. And another suggestion I have is that the FAA is so outdated, there are dozens, literally dozens of circuit splits and conflicting opinions about arbitration law. And the law about disputing should not itself give rise to more disputes. It's nonsensical. There's unclear conflicting arbitration laws. Those are a disservice to arbitration. We should not spend years litigating an issue of arbitration law. For example, courts are split over the meaning of evident partiality or whether the FAA's subpoena powers cover pre-hearing discovery. There are multiple unresolved circuit splits. And whatever way we choose, whatever policy choice we make for these splits, I think it's a disservice to arbitration for these splits to remain. And I have many other ideas that when I look back I'm a big fan of the history, and the reformers who passed the FAA, they engaged in a massive nationwide campaign to teach the public about the pros and cons of arbitration. And this amazes me. During weekends at churches and synagogues and movie theaters, the drafters created a national campaign to educate the public with press releases and talking points for ministers and rabbis to discuss arbitration and its ties to religion. And they actually had, high society, Great Gatsby-type parties to celebrate arbitration. And what can we learn from this? I think we should have a modern-day campaign to teach about the pros and cons of arbitration so there can be more meaningful public dialogue about arbitration and increase awareness. And with increased awareness, I think this can lead to greater momentum to undertake legislative initiatives or even private initiatives. I'm a big fan of the privately developed due process protocols for arbitration, but I think those are out of date. They can perhaps be updated and perhaps adopted more widely. And I think with a greater publicity campaign, maybe there would be greater private initiatives for improving the due process protocols.
I like that ambition. Steve, do you have thoughts about amending the Federal Arbitration Act?
Yes. First of all, Imre's historical research is a great service. To be able to go back to the archives and dig out the facts the way Imre has done, the history is a great service. But then on the conclusions of how strongly to criticize the Supreme Court for its current law, its current arbitration decisions diverging from what the drafters of the FAA intended, I'm more charitable to the Supreme Court than Imre is because I see arbitration law not as its own isolated area of law, but in the context of bigger changes that happened in U.S. law in the 20th century after the FAA. In particular, the Erie versus Tompkins decision and the Commerce Clause's expansion during that same New Deal era. In other words, I think it's very hard to criticize Southland, the Supreme Court decision Imre would like reversed. I think it's very hard to criticize that decision without being charitable to the Supreme Court's quandary of deciding that case in light of much bigger changes in 20th century law, the expansion of the Commerce Clause, and the Erie versus Tompkins decision. There's a wonderful law review article by Linda Hirschman on this point, but I won't go into any more of that nerdy historical detail because I see our time is running short.
Thank you so much, Steve. That's all the time we have, but before we leave, I ask all attendees who want CLE credit to stay connected for instructions to get your CLE certificate. On behalf of the ABA, thank you all for joining us. Before leaving, wait for the evaluation to come up on your screen. Thank you very much. I will now turn you over to our operator for some additional information. Operator?
Thank you. On behalf of the ABA section of Dispute Resolution, thank you for participating in this program. To learn more about the Dispute Resolution section, visit the ABA website at www.americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.